here just to kind of cover some of the basic practice tips. So on the landlord side, when you do your eviction action for evictions in the Tacoma city limits, again, make sure that that you at least reference the Tacoma business license number in your complaint. I know a lot of landlords like to keep their initial pleadings if someone's a complaint as streamlined as possible, and then they'll add in the other evidence later. But I'm a big fan of, for the Tacoma evictions, just attach a copy of the license as an exhibit to the complaint. I also like to have a statement in the complaint regarding compliance regarding the student or school year exemption. So just because commissioners like to see that, so it doesn't hurt in your complaint to have that, have your client, confirm that that exemption does not apply to this particular eviction, that the school year eviction does not apply to the case at hand. Another situation is if the rental property has a Tacoma address, but it's not in the Tacoma city limits. Again, we don't want to throw the commissioner for a loop. So go ahead, if you do a search for a Tacoma address lookup, if you Google that, it pulls up a page that the city of Tacoma hosts. You can input the address, and if the address is not in the Tacoma city limits, it'll pop up a map, show you where the property is relative to the Tacoma city limits, and it'll say not in the Tacoma city limits. Take a screenshot of that and attach it as an exhibit to your complaint. And again, we're just trying to keep things as easy as possible for the commissioner, because when they see an eviction come in front of them at the show cause hearing as a Tacoma address, they're going to be thinking of these three things. Is there a license? Is there kids, school kids involved? Is it actually in the Tacoma city limits? And if you can answer those coming out of the gate, then they're not going to be distracted when you have to argue the real issues at hand at that show cause hearing. Let's see. Oh, and talking about show cause hearings, so under the Fairness Code, you are required to have a show cause hearing if the rental property is in the Tacoma city limits. So there's no defaults allowed on that eviction action. So just be prepared for that. They cannot be evicted without a court hearing. And let me just take a quick look if I can reference them. Okay, no, thought I had it at my fingertips, but I don't. So the show cause hearing is required. Because of that, there's no, you don't know whether or not your tenant is going to appear at the show cause hearing or not. And so again, to aid the commissioners, I know particularly recently Commissioner Farmer has requested that the DMDC certificate be filed. And so if you're not familiar with that, you can go ahead and I've left the link there. You have to go online, file, and you put in the tenant's name and their birth date, and it'll kick back a report immediately as to whether or not that tenant is active duty military, right? And so it's just a sacred compliance requirement. We don't want to be defaulting anyone who is active duty military. So include that in your evidence going to show cause, and you're going to make life a lot easier for the commissioner. The last thing is, if your tenant is does have any of these exemptions, whether it's a cold weather exemption, the school year eviction, or any other exemptions they may be entitled to, on your order issuing the writ, you want to strike the forthwith language, which is typically there in any boilerplate form. So you need to strike that because they're not going to be issuing the order, the writ forthwith. They'll be issuing it whenever the exemption period is run. So you'd strike the forthwith language, and if it's a cold weather eviction, you would substitute that with April 2. If it's a school year exemption, you would put in the day after the last day of the school year. You need to take a look at that. That information is available online. Look under Tacoma Public School District school year, but it's subject to snow days and those types of things too. So you need to make sure you include that.
Next one.
I have another question.
That's
The university is here. Does this cover student housing or not?
No, based on the definition section of school. So yeah, it doesn't apply to college students. Next one. Okay, so this is a motion to stay writs, and we can kind of go through this quickly. It's available on the PowerPoints as well as just kind of a sample. What I will say is if a tenant does not show up to the show cause hearing and then wants relief, so usually the situation is going to be the tenant didn't show up for whatever reason. The writ's been issued, and the tenant then is getting, a knock on the door, and particularly if only the cold weather moratorium would apply, you're going to have some tenants who may turn to the court to say, I can't be out on April 2nd, right, for whatever reason, or maybe they have a defense. So what they'll want to do is file a motion to stay the writ of restitution, and there's a sample that's provided here. It sounds like, Amy, that there might also be a sample available on the law library website as sort of a resources. Soon. Yes. Right. And so I will also note that in a slide that's later on, in terms of Dzaman versus Gowman, that there is at least some argument that if the initial notice was non-compliant with the Landlord Fairness Code, that may also be a basis for the tenant seeking a stay of the writ. That case we'll address later on, but it's also worth noting that in that case, the tenant did not really go through the formal process for a CR60 motion to vacate the writ of eviction. But nevertheless, the Court of Appeals gave the tenant a pass and said, essentially, well, we know what you were trying to do, and applied kind of the same analysis. So I don't know that we need to spend a ton of time on these particular slides, but Adam, do you have anything to say about
the only thing
stay?
is generally, just generally commenting on these motions to stay writs. And so, as you know, the tenants now have the right to apply for free counsel, and the courts, well, they're going to enforce that right to the maximum of their ability. And so if you have defaulted a tenant at show cause, or they didn't appear at the show cause hearing, and you get your relief, if the tenant comes back, the court is going to be inclined to stay the writ based upon that alone. If they have not had an opportunity to get vetted to see if they have, if they're eligible for counsel, the court is going to give them that opportunity. What that typically means is that aside from these other reasons for staying the writ, if there's procedural errors on the landlord's part, the court can always fall back and say, well, we're going to stay the writ to give this tenant an opportunity to see if they're eligible for counsel. And at that point, the writ gets stayed, and then they'll reset the show cause hearing. And that can be done pretty late in the game. I almost hate to say it, but I've heard from in other jurisdictions where that has occurred even after the physical eviction. So you need to kind of keep your eyes out for that. So it's not necessarily over when you think it's over.
I think you're talking about a state right to indigent counsel for evictions.
Right to counsel.
Recent state statute.
Yes.
That's correct, yes. And
I will note that I have seen the courts requiring that the tenant make a payment into the registry as a condition to granting the stay, and that I think would probably affect mostly those tenants who don't qualify for the right to counsel because they do make too much. So that is something that we've seen. There's a pitfall that I think some tenants face in terms of potentially spending the money that they would otherwise pay to rent because of a dispute with the landlord or concerns about habitability. And in that case, that can be a problem because ultimately damages might be assessed. So the registry is typically a safer bet for tenants that can pay to reduce damages, or even compel or help with the negotiation piece so that maybe we can get some agreed orders. Okay, so Amy, if you can fast forward, because these are just, what the writ looks like, all the way to defending evictions for failure to comply with code. And